Welcome back to the deep dive. Today we're diving into the final stretch of the patent process, looking at Chapter 1300 of the MPP allowance in issue.
That's right. We're focusing on what happens after that notice of allowance lands. This is crucial for you, the listener, because it's really the administrative endgame.
Yeah, it's less about the invention itself now and more about the machinery that turns an allowed application into an actual issued patent.
Yeah.
We want to give you that shortcut to understanding this phase.
Exactly. Think of it as tracking the file through its last administrative hurdles. These steps are designed to catch any little error before, a potentially valuable patent goes public with a flaw.
Okay, let's get started. We'll begin with the main section governing this.
MPP Section 1309, Issue of Patent.
So the notice of allowance is mailed. What's the very first administrative step? It sounds like it moves out of the examiner's hands pretty quickly.
It does. It's basically a handoff. The Office of Data Management grabs the allowed application electronically. Then it gets exported to what they call initial data capture, or IDC.
IDC. Initial data capture. So kind of like an intake process.
Yeah, think of it as the first verification step. They're basically prepping the file, getting it ready to transition from this, fluid legal thing into a formal published grant.
Okay, so assuming it passes that initial check, where does it head next?
Then it goes to the File Maintenance Facility, the FMF. Now, these are the people you really want paying attention.
The quality control team.
Exactly. Their job is absolutely critical. They verify that every single post-allowance requirement is met. They're looking for the issue fee payment, any required formal drawings, making sure all the final correspondence is actually in the file.
Right, like that last check before you board the plane ticket, passport, everything in order. No mistakes allowed.
Zero tolerance for errors here. If everything checks out at the FMF fee paid, all requirements met, then it moves to Final Data Capture, FDC.
FTC. That sounds like the point of no return.
Pretty much. This is the final stop. The application status gets updated, and it's officially placed into issued status. It's essentially locked in for publication.
Now, for people waiting on this applicants, attorneys' timing is everything. What's the deal with getting notified about the actual issue date?
The key thing really is to watch the electronic systems. The issue notification is usually available online maybe a few days before the patent officially issues.
And the mailed copy.
That mailed notice can be slow. It might even arrive after the patent has already issued electronically. So relying on the physical mail for the date, that's just not a good strategy anymore. Always check electronically.
Okay, makes sense. So normally patents issue in order the fee was paid. But you mentioned exceptions, situations where an application can, jump the queue.
Right, that's called special handling. While the default is chronological based on the issue fee payment date, the USPTO has carved out 5 specific categories that get priority.
Why would they need priority? What kind of situations warrant that?
It's usually driven by specific administrative or procedural needs, high-stakes scenarios, basically.
Okay, run us through them. What gets this special treatment?
Well, first, there's the straightforward one. A, cases the director specifically makes special. Then, category B, which is pretty common. Cases where the earliest priority date is more than 5 years old.
So that's like clearing out the backlog, getting old cases off the docket.
Sort of, yeah. It's administrative hygiene. If a case has been kicking around through complex prosecution for 5 years or more, they want to get it finalized and issued.
Can you give an example of that 5-year rule?
Sure. Let's say you have an allowed reissue application. Reissues deal with existing patents, which might already be old. If its priority date is over 5 years old, it automatically gets bumped up for faster issuance.
Makes sense. What are the other categories? You mentioned 5.
Okay, so C is related. Allowed reissue applications in general get special handling just because they affect an already existing patent. Then things get a bit more complex legally. D is cases where the priority dates might trigger an interference proceeding.
Interference, figuring out who invented first.
Right. Exactly. If issuing the patent quickly could help resolve or even avoid a potential fight over who invented it first, the USPTO prioritizes it. And finally, E involves parties from terminated interferences.
So cleaning up after those complex proceedings are done.
Precisely. Once an interference is over, the related applications need to issue promptly to make the outcome official. So these special handling rules are really management tools to keep complex or aging files moving through the system efficiently.
Okay, let's talk about the patent itself, the actual document. There was a pretty significant change recently, wasn't there? April 2023.
Oh, absolutely. April 18th, 2023 marked a huge shift. That's when the USPTO went fully electronic for patent issuance. The traditional heavy paper ribbon-bound patent, that's basically history as the primary legal document.
So what do you get now? How does it work?
Patents now issue electronically. They come under the official USPTO seal and have the director's digital signature. You access, view, and print the official grant right from the USPTO's online systems.
And legally speaking, is this digital version just as valid as the old paper ones?
100%. The USPTO makes sure to clarify this in the regulations. It's explicitly stated in 37 CFR 1.9K and MPP Section 2128 that these electronically issued patents are legally equivalent to the printed ones. No difference in legal weight.
That they ensure it's authentic, tamper-proof.
It's authenticated using a digital seal and an encrypted signature. That ensures the integrity of the electronic document.
Now, one area that seems ripe for error is getting the names right on the patent, particularly who owns it. How is that handled?
Yes, this is a classic administrative trap. The names of the attorneys or law firms, and crucially, the assignee information, the legal owner, will only appear on the issued patent if you list it correctly on the issue fee transmittal form. That's the P2L 85B form.
Wait, hold on. So let's say a company, big corp, properly filed all the assignment documents. They legally own the invention. But if the person paying the issue fee forgets to list Big Core on that one specific form, the PTOL 85B, what happens?
Big problem. If that assignee info isn't on the PTOL 85B when the fee is paid, the patent issues listing the inventors as the applicant of record, not Big Corp.
Even though Big Corp legally owns it.
Even though they legally own it, the assignment itself is still valid, but the face of the patent, the public document, shows the wrong party as the owner at issuance. That can cause all sorts of confusion, title issues, headaches down the line.
Wow. So that PTOL 85B form is way more than just a payment slip. It's critical for the record. What if someone lists like slightly different versions of the company name on the form?
The USPTO won't try to figure it out. If you list multiple variations, they print only the first one listed. That's it. Consistency is key on that form.
Okay, so that covers the normal process,
Oh.
even with its potential pitfalls. But what happens if an error is caught really late, like just before it's about to issue electronically? Is there an emergency stop button?
There is, and it leads us right into the next section. It's the USPTO's version of yelling, "Stop the presses," but for the digital age.
MPP, Section 309.02, printer rush cases.
Exactly. The name printer rush tells you it's urgent. This gets triggered when some administrative issue is found after the application has already been sent for issuance, but before it actually publishes. It's something that absolutely must be fixed.
Okay, so these aren't substantive issues like finding new prior art. These are more procedural mistakes.
Literally, yes. They're procedural defects, but they can have serious legal consequences if not corrected. Think about things like an amendment under 37 CFR 1.312. That's a post-allowance amendment that wasn't processed. If the patent issues without it, the claims might be wrong.
What else triggers a rush?
Corrections of inventorship under 37 CFR 1.48. Getting the inventors wrong is obviously a big deal. Or maybe an information disclosure statement, an IDS was filed, but the examiner never initialed it before allowance.
The duty of disclosure implication. You need confirmation the examiner saw it.
Precisely. If that IDS wasn't properly considered, it could undermine the patent's validity later. So these printer rush items are critical administrative fixes needed before the grant goes public.
So, an issue is flagged. How does the system react? What's the rush procedure?
It's immediate triage. The application gets electronically flagged, RUGE. It jumps to the top of the examiner's docket. They have to deal with it right away.
And the examiner's role?
The examiner reviews the file, figures out what needs doing, and then annotates a specific RUSH document explaining the corrective action they took, or, importantly, justifying why maybe no action was actually needed.
How is this documented?
Yeah.
Especially if, say, no new notice needs to go out to the applicant.
Good question. If the fix requires sending something out, like a corrected notice of allowance, then that annotated RUSH form gets included in the electronic file wrapper, the eRed folder, so it's part of the public record.
And if no mailing is needed, they just fix it internally.
If no mailing is required, they still have to document the action. They create an entry in the file wrapper, usually titled something simple like printer rush no mailing, just to show the issue was addressed internally.
So the rush isn't necessarily about making the patent issue faster, but about pausing things just long enough to fix a critical error before the scheduled issue date arrives.
That's exactly it. It's purely procedural hygiene. The goal is to make sure the patent publishes on time, but correctly. This whole back-end process, from the FIF checks to the printer rush fixes, it's all about ensuring the integrity of that final issued patent document.
It really highlights that getting the claims allowed is just one part. Making sure the final grant is administratively sound is, well, arguably just as vital. Hopefully, understanding this helped you, the listener, navigate that final mile more effectively.
Absolutely. Knowing these pressure points, like the importance of that P2L 85B form, can save a lot of trouble.
We would like to extend a special thank you to Mike Sheppard, the creative director who organized this entire audio series.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.